The High Court in Pretoria will tomorrow hear the embattled National Assembly Speaker Nosiviwe Mapisa-Nqakula's urgent application to stop the National Prosecuting Authority from arresting her. She's accused of receiving over 2 million rand in kickbacks from a contractor during her time as Defence Minister. Mapisa-Nqakula has taken special leave following a raid on her Johannesburg home earlier in the week. The Democratic Alliance at the same time filing a motion to have the Speaker removed from office. All right, let's discuss this now, and we're joined by the former prosecutor and DA Member of Parliament, Advocate Glynnis Breytenbach. Advocate, good evening to you, and thank you for your time. Let's begin with what the Speaker is suggesting here, and that is that the NPA is engaged in efforts to humiliate her as opposed to seeking justice or perhaps following the prosecutorial guidelines. Do you go along with that assertion?
Good evening. No, certainly, I most certainly don't. The NPA has been at pains for the last couple of years to rehabilitate itself and to rehabilitate its image, and I think the days of that type of those type of shenanigans are over as far as the NPA is concerned. I don't believe that they would go after the Speaker for any other reason except that they have a prima facie case against her. If they were able to get a warrant for her arrest, then and a warrant to search and seize at her property, then they've certainly got a case with sufficient strength to convince a judge to sign that. It's unlikely in the extreme that this is an exercise to humiliate the Speaker. I'm assuming that in the favour of the NPA that they have at least a case that they think is that they on paper is a prima facie case.
Yeah.
And I think the Speaker's reaction is very, very telling. If you're an innocent person, you say go right ahead, search my property. You should find nothing. And if you want to prosecute me, tell me where and when I should present myself, and I will be there. There's no other way of dealing with it if you have nothing to hide. To go to court and try and get an order to prevent yourself being arrested, well, I mean, that's just nonsense. At some point, she's going to be arrested. Even if there's an agreement to hand herself over, before she appears in court, she must be arrested, just like everybody else. She's no better and no worse.
As a former prosecutor, you would know this better than we, the people who are not so clued up about the processes of the law. The Speaker says she is seeking to assert her rights, and that is why she wants a full disclosure of what the allegations are about. She wants to know who's making these allegations and on what basis. And she also asserts that the reason she claims that she is a victim of humiliation is that someone within the prosecuting authority is running a trial by media by leaking information, and some of this, of course, contained in the Sunday Times today. As a former prosecutor, have you seen this before, where someone actively blocks her arrest because they want to know exactly what it is that they are being charged with, or at least accused of?
Well, there's a variety of angles there. So, first of all, no one can block their arrest. If there's a warrant for your arrest, it will be executed. And that's just how it is. So, the Criminal Procedure Act makes provision for the least invasive method of securing your attendance in court. And so prosecutors are bound to make use of that, or for a specific date and time, or the investigating officer or the prosecutor will make an arrangement with your legal representative that you present yourself at the police station or at the court on a given date at a given time, where you will be arrested in terms of the arrest warrant. Make no error, you will be arrested and you will be processed. That means your fingerprints will be taken, records will be taken, etc.
So let me stop you there, Advocate. Let me interrupt you. Allow me to interrupt you. I apologize. Allow me to interrupt you. If the prosecutors had the warrant of arrest ready for her on Friday, and then she brings this application to interdict the arrest, why wasn't this warrant executed then?
Well, you know, you don't have to execute a warrant immediately you obtain it. You have a warrant. You'll execute it when it's the correct time and the correct place in the course of events. So clearly there's going to be a prosecution. There's been a search and seizure. The MPA doesn't have to execute the warrant on Friday or today or what. What the Speaker is trying to prevent is that she gets arrested at midnight and held in a cell. But it's very unlikely that would happen. Everybody knows where she lives. She has a job. She has a fixed abode. So it's more likely that an arrangement will be made for herself to hand herself over. So her rushing to court to prevent an arrest is, in my view, a little hysterical and premature. Her demands for information at this point also a little hysterical and a little premature. She's not really entitled to all that information at this point. When she is arrested and charged, she will then become entitled to the full contents of the docket, just like everybody else, in terms of the Constitution. She will then get all the information at the disposal of the state, and she will probably be able to prepare herself for her trial. So, you know, this hysterical reaction of hers is somewhat unnecessary in my view. And just makes it look like she has something to hide.
Before we get into some of the processes in Parliament, because she's now on special leave, some people arguing that that is not provided for. Before we get to that, do you think then, as you mentioned, that the hysteria here that is being created, it is all to do with her and perhaps the embarrassment of standing in the dock accused with such serious crimes and flashing cameras from the media? Is that what you think scares her the most?
Well, you know, I speak from personal experience. It's certainly not pleasant. But again, if you have nothing to hide, you arrive at court, you hand yourself over, you get arrested, you get processed, you get tried. If you're innocent, you will be acquitted. As she doesn't want to be standing in the dock. Well, you know, not many people do want to stand in the dock. That's life. Does she want the flashing cameras in her face? Well, it doesn't bother her up to now, but probably not under those circumstances, no. But that's going to be unavoidable. So what she needs to do is comport herself with dignity for the position that she holds. But what special leave is for the Speaker, I don't know. She should be removed. Under these circumstances, anybody else would, in a functioning democracy, would have resigned.
And so you've already touched then on the next question, the leave of absence that she has put herself in. She says she contacted the President and, of course, also contacting her party, the ANC. Is special leave provided for in the rules of the National Assembly?
Certainly not as far as I can ascertain, except for reasons of continued serious illness. In the fifth Parliament, Mrs. Mandela was granted special leave when she was very ill. You have to, if you don't come to Parliament for a certain amount of days, then there's a problem. And so in order to not be present for sittings for an extended period, you need to get special leave. But as far as I can see in the rules, it only makes provision for serious health conditions.
There are suggestions that the interdict sought to prevent her arrest is intended to buy her time so that the sixth Parliament is ultimately dissolved and that a new Parliament may not be interested in following up on her matter. Do you agree with that view?
Well, that may be what she's trying to do, but that certainly will not be the case. You know, that certainly would be expedient for her and probably is what she's angling for. I don't believe that a new Parliament would be able to ignore these kinds of conditions. The Speaker is a serious position and the charges are serious. And she will still be prosecuted whether she is a member of the 7th Parliament or not. So, you know, it's going to help her in a very limited way. She should do the honourable thing and just, you know, do what every other citizen of this country is required to do. You present yourself for arrest, you go through the trial, and if you're innocent, you'll be acquitted.
Yeah. Final question to you, Advocate. You've seen these kinds of actions, or should we say individuals who are in trouble with the law, and the minute the word impeachment is mentioned, and I believe this is what the Democratic Alliance is perhaps seeking by that complaint that you have now lodged. If it were to come to a point where a motion for her impeachment is submitted to Parliament, do you think she would wait until that process, knowing what we all know today, that the minute you are impeached, your benefits fall away? Do you think she would wait for something like that?
Well, she would look for every possible wriggle room to avoid that. I'm not sure that would be possible. The matter is urgent and it must be dealt with urgently. And if these charges stick and if she's ultimately found guilty, then she's, in all honesty, not entitled to those benefits. She has brought Parliament and the Office of the Speaker into disrepute.
Advocate Glynnis Breytenbach, thank you very much for your time.